contract. So a contract is said to be discharged or terminated when the parties to it are freed from their mutual obligations. So when they basically come to a point whereby now the parties don't have any obligation under the contract, we can actually be able to conclude that this particular contract has actually been discharged, or it has come to an end, or has actually been terminated. So the ways through which a contract can come to an end, or basically it can be terminated, is through, for example, what we call discharge by performance. So through performance of the contracts. So you can have performance. You can have what we call by agreements. So by performance, we simply mean that the parties have been able to fulfill their obligation under the contract. So nothing is actually remaining, or no party is actually under liability under the contract. So they have actually been able to fulfill their promises under the contract. So once that has been done, then it simply means that there's nothing else to be fulfilled by the parties. So most obviously, the contract will actually be terminated, or basically it will actually come to an end through what we call performance. By agreement, so parties can actually be able to agree or actually enter into an agreement that their relationship under that particular contract should actually come to an end. So if it is a contract between, for example, a lessor and a lessee, or maybe a landlord and a tenant, so through an agreement, that particular lease can actually be terminated, or basically it can come to an end. So any kind of a contract can actually basically come to an end through what we call an agreement. For example, in this case, if we assume a contract, like let's say, for example, a contract of marriage, so it is normally a contract, so the parties can actually be able to agree among themselves, or just agree upon themselves, that basically they're going to be able to end this particular relationship. So basically through an agreement, that marriage contract can actually come to an end. That is what we mean by agreement. Through frustration, so sometimes there could actually occur an event that is beyond the control of the parties under the contract. So there's nothing they can actually be able to do about it. So it simply means that that particular happening has actually frustrated the performance of that particular contract. In this case, for example, if it is a contract for a sale of a house, or an agreement to sell a house, and this house that is going to be sold, it is actually destroyed, for example, by a disaster, let's say, for example, fire. So the subject matter under the contract is not actually basically in existence. So through frustration of this particular happening, whereby the subject matter has been destroyed, it simply means that this contract cannot actually be performed. Or maybe there could be death of one of the parties. So that is an event that can actually be able to frustrate the performance of the contract, the performance of the contract. So frustration, so a contract is said to be frustrated if an event occurs which brings its further fulfillment to an abrupt end, and upon the occurrence of the frustrating event, the contract is immediately terminated and the parties are actually discharged. So for example, in this case, a contract can be frustrated through what we call destruction of the subject matter. So just like what I'm telling you, destruction of that particular house that was supposed to be sold. So that is the subject matter under the contract. So in this case, it simply means that it can actually be terminated through the destruction of the subject matter, death or incapacity of one of the parties, death or incapacity of one of the parties, frustration of the common venture, so where both parties contemplate a particular object as forming the basis of their contract. Such object constitutes the common venture. So the law is that if the common venture subsequently becomes incapable of fulfillment, the contract is actually frustrated. So if their interests cannot actually be fulfilled, maybe due to change of law, or maybe due to the regulations governing that basically performance or venturing into that particular venture, it simply means that this particular agreement to enter into the venture can actually be frustrated, and the contract or an agreement to invest in that particular venture can actually come to an end. Discharge by breach, for example, if one of the parties actually breaches his obligations, so the other party can actually be able to take a step to terminate the contract or terminate the agreement. So discharge through what we call a breach. Discharge through what we call breach. So failure of performance or basically to carry out a duty by one of the parties or to carry out his mandate under the contract by one of the parties, that simply means that there's actually the breach of the agreement. So that breach of the agreement can basically lead to the contract having to come to an end or actually being terminated because one of the parties is not actually playing his or her role under the contract. Then discharge by operation of law. So discharge by operation of law. So a contract may be discharged by operation of law in certain cases. So this means that once that particular event actually occurs, automatically the contract will be seen to have actually come to an end. So under the law, if that particular event actually happens, it simply means that the contract will actually be terminated or actually be discharged. So under operation of law, so it can come to an end through the following. So lapse of time, for example, if the time has come to an end, the contract basically will be discharged or terminated. If it was a lease for, let's say, for example, 2 years, and the 2 years have actually come to an end. So the contract, due to lapse of time, will be seen to have actually been terminated because the agreement was to enter into a 2-year lease. And of course, the time has actually already elapsed. Death of one of the parties. Substitution. So if a contract is substituted with another contract, so this simply means entering into a new contract or basically having another contract substituting the previous one. The previous one basically will actually automatically be terminated or discharged. Bankruptcy of one of the parties. So for example, if it is a corporate entity that is entering into a contract, if that corporate entity becomes bankrupt or is declared to be bankrupt, so it simply means that this particular contract will actually be terminated or will actually come to an end because that company you are working for has been declared to be bankrupt. It cannot actually be able to meet its obligations in terms of actually being able to pay even the employees or the creditors of the company. So the company can actually be liquidated or its life can come to an end. So once declared bankrupt, it simply means that all the creditors are actually all over you. And of course, you cannot continue to function as a company. So all the other contracts you entered into, because you are not an entity in existence after that particular declaration of bankruptcy, then of course it simply means that all the agreements that you had entered into as an entity or a company will simply be terminated or can actually come to an end. So what are the remedies, for example, if there's what we call breach of contract? So what are the remedies you can actually be able to take? In this case, if, for example, the teacher is not actually able to provide the tuition as per the agreement, it simply means that you can actually be able to take certain steps and actually be able to go to the court. So if you go to the court, these are the remedies the court can actually be able to provide, or basically the reliefs. So they can ask the defendant to pay for all the damages. So they can ask him to pay for all the damages that you've incurred as the plaintiff. Quantum merit, so basically pay for the work already performed or work already carried out, or the quantity of work that has actually already been carried out. For example, if the contract was actually to work for maybe a month, and of course, in between the month, abruptly, the employer terminates the contract without any notice. So it simply means that the court might declare that he pays or basically pays for your performance under what we call quantum merit for the number of days you had actually worked in that particular month. That is what we mean by quantum merit. So pay for the quantity of work that has actually already been done or performed by the other party. Specific performance, so the court can declare or basically order one of the parties to be able to ensure that he has actually performed his bits. So in this case, if a particular party has failed to pay a particular fee or basically pay a price for particular goods, so the court can actually be able to declare that that particular party who has failed to pay for the goods to pay for the price, because maybe he has actually already consumed the goods, so he cannot return them to maybe the seller of the goods. So that failure to pay for the price can lead the court to basically declaring that he fulfills his obligation in terms of having to pay for the price of the goods. Then we have injunction. So injunction simply means that the court orders that there is stoppage of continuance of performance of the contract if it is not actually being performed as per the terms or the promises given by the party under the contract. So under specific performance, whereby you are saying the relief is specific performance, under certain circumstances, this may not actually be a remedy. So it's not a remedy the court can actually be able to take or basically force a party to basically perform his contract. For example, where monetary compensation is an adequate relief. So this is an exception whereby the court might not actually basically go ahead and actually give what we call specific performance as a remedy. So if money can be paid to compensate the other party, there's no actually need to ask or force a party to be able to perform his obligation, so long as he has actually agreed, maybe, for example, to pay for all the damages. So where monetary compensation is actually an adequate relief, is an enough relief, there's no need for ordering for specific performance by the court. Number two, where the court cannot supervise the actual execution of the contract. So the court might not actually be there to basically ensure that a party is performing his obligation or it is carrying out performance under contract. So if the court is not actually satisfied that they'll actually be able to supervise this, then they won't give specific performance as a relief, because they might end up giving specific performance as a relief, yet that particular party might actually end up not actually being able to perform his duty under the contract. So where the contract is for personal services, e.g. a contract to marry or to paint a picture, in such contracts, injunction, or basically injunction, an order which forbids the defendant to perform a like personal service for another person, is granted in place of specific performance. Then the last one, where one of the parties to the agreement does not possess competence to contract and hence cannot be sued for breach of contract. Thus, a minor cannot succeed in an action for specific performance. So if one of the parties has no capacity or capability to perform a contract, then he won't actually succeed in case he sues for a remedy or basically seeks for a remedy of specific performance, because he doesn't have the rights to be able to perform the contract. Then injunction, as we've said, injunction is an order by the court restraining a person from doing a particular act. It is mode of securing the specific performance of the negative terms of the contract. So the court might give out an order that the stoppage of continuance of performing of a particular contract or a particular promise. So to put it differently, where a party is in breach of negative term of a contract, where he is doing something which he promised not to do, the court may, by issuing an injunction, restrain him from continuing to do that particular act. So what he promised not to do. So that injunction is a preventive relief if it is particularly appropriate in cases of anticipatory breach of contract, where damages will not be an adequate relief. So we are saying that injunction can actually be given in case there's actually negative performance of the contract. Maybe someone is doing something that was not actually basically under the promises or the terms of the contract. So he had actually promised to do this, but of course he's actually doing maybe the opposite or something that is actually quite negative to what he promised to do. So to stop the continuance of this negative happening to continue, then the court can give out an injunction or an order to stop this particular negative act or promise to continue to happen. Then the last one, what can actually happen as a remedy? So they can basically be what we call rescission or cancellation of the contract. What we mean by rescission is basically simply to cancel the contract in case of the breach of the contract. So when there is breach of contract by one of the parties, the other party may rescind the contract and need not to perform his part of obligations under the contract, and may sit quietly at home if he decides not to take any legal action against the guilty party. But in the case of an aggrieved party, if he intends to sue the guilty party for damages for breach of contract, he has to file a suit for decision of the contract. So when the court grants a rescission or cancellation of the contract, the aggrieved party is freed from all his obligations under the contract. So that is basically what we mean by a rescission of contract, cancellation of the contracts, or basically ensuring the contract has come to to an end. So that is basically the end of the law of contracts. So you can look at sale of goods. You can look at sale of goods as one of the contracts. So under sale of goods, the parties under the contract is normally a seller of goods and a buyer of goods. A seller of goods and a buyer of goods. So it is simply a contract whereby one of the parties, known as a seller, agrees to sell goods to a buyer, and of course, the consideration being paid by the buyer of the goods is actually to pay for the price of the goods, to pay for the price of the goods. So we are saying under sale of goods contract. So we're saying sale of goods So the parties will be the buyer of the goods, the seller of the goods, and the buyer of the goods. Buyer of the goods. So it is simply a contract where this person you are calling a seller of the goods agrees to sell goods to a buyer, and of course the consideration being paid by the buyer is what we call price for the goods. So the buyer will actually be able to pay for the price of the goods. So a contract of sale of goods can be defined as a contract in which the seller transfers or agrees to transfer the property in goods to the buyer for what we call money consideration, basically to be able to pay for the price of the goods in form of money. So this money consideration is what we're actually calling a price. So property means the general property in goods and not merely special property. This contract can be separated into two sale contracts and an agreement to sell. So sale of goods should be distinguished from the following transactions. For example, contract of barter or exchange. Because under contract of barter or exchange, there's usually no what we call price to be paid. So it cannot actually basically be considered as a sale of goods contract, because you are saying the key essentials that this party should actually be able to give what we call money consideration, or actually be able to pay for the price, to pay for the price. So what are the key essentials, or basically what are the what is the nature of a sale of goods contract? In a sale of goods contract, we'll have a person known as a seller. So this is the person who sells or agrees to sell the goods. Then we will have what we call property in the goods. So this is the general property in goods or ownership. It signifies the bundle of rights that a person has in relation to the subject matter. e.g., right to use, misuse, or dispose. So of course, before actually the goods are actually sold, the property in the goods should actually be in the name of the seller of the goods. So it has to be identified whether this seller has what we call the property in the goods. Does he have ownership in the goods? So once it is identified he has ownership in the goods, or basically he has property to the goods, then of course the right to sell will actually be there, and of course he can transfer the title or the property to the buyer. So goods include what do you mean by goods in this case? All charters, personal or other things in action and money, and all implements, all industrial growing crops, things attached to or forming part of land, that is, for example, buildings. So anything that is actually attached to land and can actually be sold. So types of goods also can actually be specified as ascertained or existing or future goods. So specific or ascertained goods, these are goods that have specifically been identified and agreed upon by the parties at the time when the contract of sale is made. Existing goods, these are goods owned or possessed by the seller at the time when the contract of sale is made. The contract of sale is actually made. Then future goods, these are goods to be manufactured or acquired by the seller after the contract of sale is actually made. So these have to be manufactured. So basically, they'll be seen as being goods at a future date. So another key essential element that must actually be there under sale of goods, we are saying there must be a person known as a buyer. And of course, the last thing, this buyer of goods will actually be able to pay for what we call a price as a consideration. So those are the key essentials, or that is the nature of a sale of goods contract, the nature of a sale of goods contract, that will have the sale of the goods. So this sale of the goods will actually be able to have property in the goods. Then of course, this property in goods will actually be passed to a person known as a buyer. So a person known as a buyer. So this buyer will actually be able to pay for the price of the goods. So that is the nature and how a sale of goods contract will actually be formatted, or can actually be able to come up. So under sale of goods, so the price can actually be determined, or it can actually be fixed. So always, you can actually always negotiate with the buyer as to what will be the price of the goods, or sometimes it can actually be fixed by the contract itself, or in the manner thereby agreed, or by the course of dealing, or how you are dealing as parties. In this case, how do you deal with each other as the buyer or the seller of the goods, as the buyer or the seller of the goods. So they can be oral. So sometimes sale of goods contract can be oral, they can be written, they can be partly oral or partly written. So they can be implied by the conduct of the parties. So a sale of goods contract can actually just basically actually happen orally. So you can actually be able to approach any person who is selling goods, for example, a hawker. You enter into an agreement, and of course, this particular hawker will actually be able to leave maybe a piece of cloth, or maybe a piece of shoes, or maybe shoes to you. And of course, you'll actually be able to pay for the price. So it is not actually always that basically it will actually be in writing. So it can actually happen orally, or partly orally, and actually partly in writing. So it simply just depends with the party. So that's how basically you can actually be able to come up with what you are calling a sale of goods contract. So it can actually happen orally, so by simply discussing among you as parties under the contract. So what are the terms? What are the terms of a sale of goods contract? What are the terms of a sale of goods contract? What are the terms of a sale of goods contract? So they can be classified as conditions and warranties. So the terms, what do you mean by terms? These are simply representations in the contract, representations which form part of the contract and actually will be included in the contract. So they can be categorized into conditions, or they can be categorized into what we call warranties. So conditions are simply those terms under contract that must be fulfilled for it to be concluded as a proper contract, or basically a contract that has actually been performed. If they are not actually fulfilled, it simply means that the contract has not actually been performed. For example, in this case, if the buyer does not actually pay for the price, the contract is not actually complete. So payment of that particular price can be termed as being a condition under the contract. It is simply that term that must be fulfilled. When you talk about a condition, is that term that must be fulfilled for it to be concluded that the contract was actually performed. In this case, if the buyer of the goods does not actually, the seller of the goods does not deliver the goods. So if he does not deliver those goods as his or her consideration, it simply means that this particular contract has not actually been fully performed. So that is a condition. It is a condition under sale of goods that, for example, the seller of the goods will be able to put the goods in a deliverable state. Or basically, the seller of the goods will likely be able to have what we call property in the goods or title in the goods. If he doesn't have title in the goods, it simply means that the goods do not actually belong to him as a seller. So he cannot actually be able to pass what we call a good title. For example, in this case, the goods will actually be of what we call merchantable quality. So the goods are actually expected to be of good quality before you can actually be able to buy as a buyer. So you can't actually be able to buy what we call maybe expired goods. So this simply means that the goods are not actually in a good condition, or they're not actually of merchantable quality to be consumed by you as the buyer. So it is actually always important that this particular condition is actually fulfilled under what we are calling a sale of goods contract. So some of these particular conditions, we are saying they can actually be implied by the statutes. So they can be implied by the statutes or by courts of law. So what are the implied terms under implied terms by statute under the sale of goods contract? So the conditions, those ones that must be fulfilled. Number one, the seller has a right to sell the goods when the property in the goods is to pass. So what do you mean by the seller has the right to sell the goods or to pass the title of the goods? It simply means that he has a good title to be able to pass. It's like if it is a piece of land or maybe it is a motor vehicle, that logbook, that particular logbook under the motor vehicle is actually written in his or her name. So he has a title to be able to pass, or the title in the goods to be able to pass to the buyer of the goods. So that is a condition that must actually be fulfilled. So it is actually very important. Then in case of sale by description, the goods shall correspond to the description. This condition applies where the sale is solely for description. So the way you've described the goods should actually be able to ensure that those goods are actually as per the description you've given us, the seller of the goods as the seller of the goods. Then where the buyer expressly or by implication makes known to the seller the particular purpose for which the goods are required, so as to rely on the seller's skill and judgment, there is an implied condition that the goods will be reasonably be fit for purpose. So where the goods are bought by description from a person who deals in such goods in the ordinary course of the business, there is an implied condition that the goods will be of what we call merchantable quality. So then if the goods are being sold through what we call a sample, that the rest of the goods will actually correspond to the sample provided by the sale of the goods. So these are the conditions that must be fulfilled before we can actually be able to conclude or basically be able to see that a contract of sale of goods has been performed or has actually been fulfilled by the parties. That is the seller and the buyer of the goods. That is the seller and the buyer of the goods. Okay, sorry about that. So we are saying basically the terms can be categorized under conditions and warranties. So we've just gone through the conditions. So the warranties are normally just two of them. So two major ones. The first one, the first warranty. So what we mean by warranties, these are simply terms that it is not mandatory for them to be fulfilled, but it can still be seen that the contract has actually been performed. So number one is the goods are free from undisclosed charges or encumbrances. So their goods are actually free from charges or encumbrances. Charges or encumbrances. What we mean by charges or encumbrances is that these goods might have been used as a form of security by a seller. So sometimes might not actually be easy for you to be able to determine this one as the buyer of the goods. Maybe you'll just realize it later on after you bought the goods. So that is basically something that cannot actually be able to prevent the seller to be able to sell the goods to you. You might realize maybe later on. So we simply mean that these goods are actually maybe having some form of charges or encumbrances or have been used as security, but you're not actually able to realize as the buyer. It can still be seen that the goods have already passed to you as maybe the buyer of the goods, yet there are charges or encumbrances to these particular goods. So it is not something that can prevent the contract to be fulfilled or basically be performed, but is actually one of the warranties that should actually be observed by the sale of the goods, that these goods must not actually be having what we call charges or maybe encumbrances. So the next one is that the purchaser will actually be able to enjoy what we call quiet possession. What we mean by quiet possession is that after you bought the goods as the buyer, there won't be any form of disturbance each and every time by the sale of the goods. But in this case, you might not actually be able to realize this one unless maybe you actually already acquired the goods and you already have the possession or even the title of the goods. That's when maybe you might realize that this particular sale of the goods might not actually allow you to enjoy quiet possession. So the purchaser will enjoy quiet possession of the goods. This acts as an ongoing assurance that no one will interfere with the buyer's right to possess or use the goods. So there's a case law there of microbids versus Vinhurst road markings of 1975. So the claimant purchased some road marking machines from the defendant. After the purchase, a third party was granted a patent right in the machines. This meant the claimant could not use the machines unless they were granted a license to do so. So the claimant purchased some road marking machines from the defendant. After the purchase, a third party was granted a patent right in the machines. So another party actually acquired a right over the machines. This meant the claimant could not use the machines unless they were granted a license to do so by the patent acquirer. So there was no breach of condition, as at the time of sale, the seller had the right to sell the goods. However, there was a breach of warranty in that the buyer could not enjoy quiet possession of the goods after he bought them. So all the time he basically was actually disturbed by the person who had actually acquired a patent over the goods, a patent of the goods. So a patent is basically acquisition of the right, or basically acquisition of the right to be able to use the goods, maybe in any form of innovation. So he had no control, but he had to get a license from the patent owner. So in this case, it means he was not actually able to enjoy quiet possession or acquisition of the goods. So this can only just be realized after basically the possession of the goods has actually been able to pass to the buyer. So it is simply just a warranty that cannot actually prevent the title in the goods, or basically the goods, to pass to maybe the acquirer or the buyer. So the contract can still be fulfilled even if there's actually failure to observe this particular warranty. So terms implied by the courts. So these were the terms and conditions under the statute. So the courts of law usually are reluctant to imply terms in a contract, as it is the duty of the parties to agree as to what the contractual terms shall be. So in most of the contract, the court might not actually come in to basically set or state how you're supposed to enter into a contract. You as the parties under the contract, you as the buyer and the seller, you are the one who will actually be able to agree the terms and conditions under the contract. So there are circumstances, however, where the courts are actually called upon to imply terms in a contract, reasons being to give effect to the intentions of the parties, and then also to facilitate commercial transactions or give business efficiency. Courts of law imply terms in contracts on the basis of reasonable, the reasonable standard of tests or trade usages or actually customs. So those are some of the exceptional circumstances whereby the court might actually be able to come in to ensure that the parties actually fulfill their intentions under the contract, or maybe ensure the usages and customs under certain contracts are actually being observed by the parties, are being observed by the parties. So those are the conditions and warranties under a contract of sale of goods. The conditions and warranties under a contract of sale of goods. So I would wish to end the class there. So maybe we'll meet next time and wind up on this particular contract of sale of goods and actually start on the next topic, or look at the other topic. So I hope that is okay with you, Becky.
Yes, I'm okay.
You're okay with that? Huh?
Yeah.
How are you finding this particular unit? Because there was no any big difference that was done from the previous syllabus. So you'll be sitting for your exam this coming December, or you will still postpone?
I will have to sit for it.
You'll have to sit for
when
it.
Is the exam?
The exam is, it will start around December 15th. Have you booked?
December?
15th, from December 15th.
15th? Yes. I haven't booked. Okay, when is the deadline? 15th?
I don't know the date. Was it extended? It was supposed to be end of this last month, but I think it was extended. You are aware it was extended?
Yeah.
Up to when?
I think it was extended till 15th.
Or 15th. So maybe you can look and see if you can be able to sit for the exam. Are you still in Nairobi, or you?
No, I was deployed to Larry sub-county. You know Larry sub-county?
Larry is where? It's in which county?
It's the town next to Limuru. I think you know of Kimende.
Kimende, I know. This after this place where there's normally a lot of cold.
Sure. So I was deployed there, and I'm staying there currently.
Oh, how are you finding the environment there? Have you settled?
Yeah, I've settled. I've been here for almost 3 weeks. Yeah, I think it's the 3rd week now.
Oh.
Yeah, so I'm still coping. But least, so far so good.
At least your prayers were answered.
Sure, because it's not that far.
Your prayers were answered.
My prayers were answered.
That is so good.
It's not that far. Yeah, because it's only an hour to town.
Because if it's not that far, you can see even when you are there, the internet is stable. You can do your things here and there.
Yeah, sure.
You can imagine
the environment is good.
You can imagine if you had been deployed to somewhere like, let's say, for example, Garissa, there.
I don't want to think about those areas now. Actually, there's no lady who was deployed there.
Or
the northern region, northeastern region.
Hostile counties, eh?
Yeah.
Then maybe there they take people who have been there for quite some time. They have some form of experience. Like I have a friend of mine. He used to be in. He used to be in the Gatanga.
So Gatanga, Muranga.
He used to be in Muranga, Gatanga. Then he has been with the government as an assistant commissioner for like around 4 years or 5 years, since around 2016.
2016
there. So
2016.
So he was deployed to Garissa.
Oh, he's in Garissa.
Lodwar, actually Lodwar, not Garissa, Lodwar.
He's in Lodwar.
Yes.
So najua nakulia kabisa hardship allowance.
So the allowance is hefty, or is it so hefty?
Yeah, the hardship allowance. Yeah, also depending on the job group. Yeah, plus we are normally given the AIEs.
Oh.
Interest.
Oh.
But that is quarterly.
Oh. Oh,
yeah.
So it's even though the environment is hostile, but the allowances are.
Yeah, the allowances are good.
Are good, eh?
Yeah, plus the administrative allowance also.
Oh.
Yeah.
So we'll talk later.
It's okay.
You have a good night.
Thank you so much.
Sawa.
Aye.
Aye.
The adjustment behavior is always the same as that of internal record.